Enforcing in France a judgment handed down abroad may seem in theory a simple formality. In practice, however, the process is fraught with conditions, competing legal regimes, and procedural pitfalls. This video in 10 chapters identifies the main traps, from indirect jurisdiction to service of process, including public policy, default judgments, provisional measures, and asset seizure, to secure effective recognition and enforcement. Before entering the details, let's begin by placing your decision in the correct legal framework. This is the key to the entire strategy. Identifying the applicable regime is decisive because the conditions, procedure, and effects of recognition differ depending on whether the judgment was rendered within the European Union by a state bound by a convention with France, or failing that, by a judgment governed by French international private law. Three frameworks dominate: European regulations, for instance, judgments rendered within the European Union, certain bilateral or multilateral conventions, and, in the absence of such a text, French general law based on judicial criteria. Each framework has distinct requirements. The answer is yes. This happens when several instruments coexist, main decision, provisional measures, or when special conventions apply to a specific matter. Instruments must then be prioritized and the most effective route chosen. If no international instrument applies, French general law takes over. Let's see what the judge examines in such cases. The judge routinely checks the indirect jurisdiction of the originating court, compliance with substantive and procedural international public policy, absence of fraud, respect for due process rights, and whether the foreign decision contradicts any prior French judgment. The French judge examines whether, in light of the case's connections, the foreign court could reasonably be seized. Jurisdiction deemed excessive under French standards may lead to refusal of exequatur. The answer is yes. A contradiction with a definitive French decision may prevent recognition in order to avoid irreconcilable judgments on French territory. Even an excellent judgment cannot circulate if international service was not properly carried out. International notification is risky because a failure of proper service, per applicable conventions or the receiving state's law, often generates a refusal of exequatur for violation of due process rights. It is crucial to identify the relevant method, Hague Convention, authorized diplomatic or postal channels, respect language requirements, and keep proof of receipt or a serious attempt at delivery. If the judgment was by default, it must be shown that the defendant was given an opportunity to defend and, if needed, that an avenue for reversal or appeal existed and was effectively available. Let's move to the most sensitive filter, substantive and procedural international public policy. Substantive international public policy is breached by manifestly disproportionate awards, very high punitive damages, blatant disregard of fundamental rights, or decisions flouting essential rules of French law. Serious breaches of a fair trial are targeted: lack of impartiality, unreasonable delays, or a concrete impossibility of presenting a defense. Scrutiny is minimal, but applies to clear violations. By tailoring the exequatur request, narrow what is asked, isolate potentially sensitive points, or if needed, propose partial enforcement consistent with public policy. In the European Union, recognition is automatic, but practical enforcement still has pitfalls. Recognition is automatic for European Union judgments, but practical enforcement still requires formalities, certificate, translation service, and can be refused on limited grounds. Irreconcilability with a prior French judgment, manifest breach of public policy, or violation of due process remain grounds for opposition even under the European Union regime. Their enforcement depends on their nature and compliance with the adversarial principle. If made without the other party being heard, their circulation and enforcement in France are more problematic. Foreign provisional measures require careful adjustment before attempting enforcement in France. Enforcement is complicated because such measures often require stricter control of the adversarial principle, jurisdiction, and connection with France, and sometimes breach public policy through excessive effects. In certain frameworks, yes, but the opposing party can seek revocation if their rights were not respected. It's best to anticipate a rapid adversarial hearing before the French judge. The answer is often yes, since the French measure better suits assets located in France and avoids two layers of scrutiny at exequatur and at collection. Clear operative terms and accurate calculations condition the success of downstream seizures. Verify the starting date, rate, and authorized capitalization, then convert to euros at the date set by the enforcement judge. A wrong calculation can compromise the seizure or expose to a justified challenge. Awards in foreign currencies require clear conversion and express mention in the exequatur order to avoid later uncertainty during seizures and payments. Yes, exequatur can be limited to certain heads if others breach public policy or are insufficiently established, enabling faster enforcement on the essential parts. On the documentation side, rigor often makes the difference between success and refusal. The enforceable copy of the decision, proof of enforceability in the country of origin, evidence of service, and in some regimes an ad hoc certificate. Without these, the application is incomplete. As soon as a French court is involved, a full sworn translation, or at least certified extracts covering the operative and pertinent reasoning, is recommended. Except for some European or conventional regimes that waive these, apostille or legalization may be needed to confirm the authenticity of the documents produced. Obtaining the order is not enough. Effective recovery happens at the seizure stage. Identify attachable assets, choose the right enforcement method, garnishment, property seizure, seizure of shares, and serve third parties under the enforcement judge's supervision. Failing to map assets, ignoring existing lien rankings, omitting interest and costs in seizure acts, or neglecting bailiff and debtor objection periods lead to practical delays. Yes, coordinated action across jurisdictions maximizes recovery, provided the risks of double seizure and jurisdictional conflicts are managed. To conclude, methodical planning. A realistic calendar avoids time bars and blind spots. Start by securing international service, gather documents for exequatur, anticipate translations, then launch the application or proceedings. At the same time, prepare asset seizure to act as soon as the order is issued. Aim for a targeted, perfectly documented application, rather than an overbroad one that invites challenge on public policy or indirect jurisdiction. Include robust jurisdiction and applicable law clauses, regulate cross-border service in the contract, and set up real or personal guarantees on assets in France. The success of recognition and enforcement in France relies on three pillars: choosing the right regime, ensuring procedural regularity, service documents translations, and preparing recovery from the outset. A methodical approach avoids refusal of exequatur and maximizes effective asset seizure.